Good morning. This is the Energy and Carbon Management Commission. It's Wednesday, June 24th at 9 a.m. We start with a roll call.
Thank you. Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 5 commissioners present.
All right. Well, we've got a busy agenda. Before we get into the agenda, we start with commissioner comments. I have a couple of commissioner comments. First, we held our all hands meeting yesterday, which is when everybody at ECMC gets together and talks about the work that we do. It's always a joyous occasion. Yesterday was not quite as joyous because it was announced that Director Julie Murphy will be leaving the department later this summer to pursue next steps in the energy and geothermal world. A heartfelt thank you to Julie from the commissioners. Our accomplishments at this transformed agency are due in large part to your leadership, your patience, your presence, and your understanding how to get the most out of ECMC and our stakeholders. Your leadership helped us to strengthen Colorado's approach to energy development, to expand the agency's mission, and built the foundation that serves to protect public health, safety, welfare, wildlife, and the environment while supporting responsible energy innovation. We're going to miss you. With that said, DNR Director Dan Gibbs also asked Jennifer Walker Graff, DNR's current Assistant Director of Energy Innovation, to be the acting division director. I'm excited about that. I wholeheartedly believe that in appointing acting director Graff, DNR has found the right person for the next steps at our agency. So we wish you well, Julie. We welcome you with open arms, Jennifer, and we will continue forward with the mission here at ECMC. That's the most important public comment or commissioner comment I had. I did have another one that is important, but not at that level. Recently, ECMC entered into a revised longstanding memorandum of understanding between ECMC and the Bureau of Land Management. This is a routine coordination document between state and federal regulators and does not change or expand either agency's legal authority. The first MOU between BLM and ECMC, then COGCC, was in the early 1990s. The amendment helps clarify how ECMC and BLM Community Colorado communicate, how they share information, avoid duplication, and coordinate on energy development where state and federal responsibilities overlap. ECMC will continue to regulate consistent with Colorado law and commission rules, while BLM will continue to carry out its federal responsibility for federal lands and federal memos. The MOU simply updates the playbook for how state and federal regulators coordinate. It does not change the rules of the game, and it was a bit overdue in terms of getting it updated. So that document's out there. Wanted the world to be aware that amended BLM Colorado ECMC MOU is now in the books. Those were the comments that I had as commissioner. I'm looking around. Do other commissioners have public comments? Commissioner Messner?
Thank you, Mr. Chair. I did want to update the commissioners on the Colorado Produced Water Consortium meeting that occurred a couple of weeks ago. It occurred on June 12th. It was down in Trinidad, Colorado. It was 11th and 12th, actually, with the meeting on the 12th. On the 11th, we had the opportunity to do a tour of some different sites in the Raton Basin, looking at ways that produced water is being beneficially utilized outside the oil field, different treatment mechanisms for surface discharge, and a general tour of oil and gas operations in the Raton Basin so that produced water consortium members have a better perspective of the different operations that are happening in different parts of the state. That would be the third major basin that the consortium has visited now. And so The next day, then we had an opportunity to interact with some of the elected officials and community members around produced water and the importance and opportunities, as well as challenges associated with beneficial use of produced water in the Raton Basin. We heard from all three county commissioners, the mayor of Trinidad, Representative Ty Winters, as well as a number of landowners, ranchers, and community members on the different challenges and opportunities that produced water creates in the Raton Basin, in an area that is experiencing extreme drought conditions, not only this year, but on a regular basis, and the importance of water to the community down there. We also heard from Dr. Karen Voltura, who's the statewide energy lead for Colorado Parks and Wildlife, about produced water management on state parklands, as well as state wildlife areas that are in that area. We heard from John Lipka, who is from Evergreen Natural Resources, on different ways that that operator manages produced water in the Raton Basin, and heard from the operator about some of the challenges and opportunities that they see around produced water in the basin. And then we heard an update from Rick Allison, who's the Northwest Area EPS and Groundwater Investigation Lead for ECMC, on the Raton Basin study, which this commission has heard the results of as well. But that also highlighted some of the challenges associated with constituents that may be in some of the produced water there, but also some opportunities that may be available around treatment of produced water. We ended up not being able to finish our full agenda there. And so we are holding another Colorado Produced Water Consortium meeting this Friday. It's a virtual meeting. The agenda is available on the Colorado Produced Consortium website. We'll be reviewing some of our experiences and findings from the Raton Basin meeting and tours, discussing some next steps for opportunities and challenges associated with produced water in the Raton Basin, and then looking ahead further into 2026, 2027, as far as other important items that the consortium will be looking to work on. So the YouTube video is available on the consortium website from the previous meeting. And if anyone's interested in attending Friday's meeting, it'll be available, or the agenda is available on the website, and the link for the virtual meeting and public comment. All of the consortium meetings is taken. And so if you're interested in providing public comment at that meeting, you can sign up on the website as well. So that is my update.
Thank you, Commissioner Messner, for the update on that important topic. Others with thoughts, comments, questions? All right, seeing none, the next scheduled matter on our agenda is public comment. We had 2 written public commenters and half a dozen or so public commenters that wanted to speak this morning. Pulling up my list, the first person is Andrew Pinkowitz. Everyone will have 3 minutes to present. And I believe, if I'm looking at the docket correctly, a number of the public commenters are speaking to the administrative orders on consent that will occur later today. So we will ensure that those public commenters' information gets into that docket. Mr. Pinkowitz, you are recognized.
Good morning, Chair Robbins and commissioners of the Colorado Oil and Gas Conservation Commission, the Energy and Carbon Management Commission. Even though this body's name was changed in 2019, the previous culture of this commission remains very much the same. Today, we're meeting about how the ECMC failed to enforce $7.7 million in fines for 5 fracking operators who all falsified data in their reports. In all 5 instances, this very body, the ECMC, alleges violations of Rule 207 and Rule 602, covering reporting and general safety requirements. And yet, despite operators outright lying to this body and surrounding communities, They continue to operate while this body clutches their pearls, wags their finger, and says, "You better not do this again." Can we imagine for a moment what data falsification in other industries would mean? Can you imagine if a pilot lied about where he flew a plane of passengers? What if a surgeon presented false data about a procedure he just completed? I am quite positive that the consequences would be far more than a simple verbal admonition and a pittance in fines. There's a common expression: when someone shows you who they are, believe them. You have evidence of falsified data for all 5 fracking operators in this hearing. It is long overdue for this body to exercise its authority and enforce penalties for operators who outright lie in their reports and endanger the public as a result. We know that unreported emissions and spills from fracking wells can cause serious health outcomes such as asthma, heart disease, childhood cancer, and birth defects. This commission has repeatedly failed its mission that it espouses to protect public health, safety, welfare, the environment, and wildlife resources. The good news: this body can start today. Enforce the outstanding penalties for the fracking operators in this hearing for falsifying data and lying to both this commission and all of the people of the state of Colorado. Thank you.
Thank you, Mr. Pinkowitz. We now will hear from Randy Willard.
Good morning, Commissioners. Thank you for hearing my comment today. Here we are again with the Commission explaining to the public why the industry gets so much leeway and deserves our sympathy. Does any of you realize that the Colorado wheat crop has functionally failed this year? Were you aware? This is what climate change looks like: dry, windy winters with little snow, warm spring seasons with minimal rainfall, a Colorado River basin that won't service all 40 million people downstream this year because there simply isn't enough water. Our state's answer: permit every application. A quote from this article on the looming disaster states, "I had farmers who have been farming 50, 60 years say it's the worst they've ever seen. It's the worst at least since 1965. Tell us again why every application is perfect by the time you see it. Tell us how you've never approved an application that puts the public at risk. Tell us how incredibly protective your precious rules are while you pick and choose which are important and which to enforce. Tell us how we will get a break on our next speeding ticket or parking ticket. What's the calculation? Wipe out the top 75% for being a good citizen and reducing the rest by 25%? Can I call you all for advice on finding my next one? Next, let's look at how the Commission and others like it in oil and gas states have been railroaded by an aggressive and unethical industry to permit so they can drill. What has the impact been on these states? Let's look at Arlington, Texas, where every school in the independent school district has tens to hundreds of wells within a mile. Now let's take a quick look at Greeley. Weld County. Seems the problem there is as bad or worse than it is in Arlington. The vaunted health panel is going to read their outcomes later today, and I'm betting that somehow our health experts in that panel have found a way to back the industry position on proximity, also known as setbacks. Let's guess that the 15 years of research in the Colorado report and over 10 years from Pennsylvania are routinely pushed aside to ensure industry dominance. When will we stop experimenting on children and the public? When will real, valid studies be included in our rules? When will industry information be placed in the trash where it's always belonged? With our government in complete lame duck mode, Governor, I expect little change to be made over the coming months, but I do believe that you all could decide to do your jobs as they are specified in your mission. When will the industry be paying the full fines they incurred? What are the rules for if we don't enforce them? How can they be considered safe if industry is allowed to thumb their nose at them and break them, knowing the price of doing so will have little to no impact on their bottom line, knowing that yet again they've gotten off without paying what they owe and what we all deserve? So many issues. So let's bring it back to your mission: to regulate in a manner that protects public health, safety, welfare, the environment, and wildlife resources. That's it. I've never seen the part in the mission that says permit all applications so the state doesn't get sued and so that the people of the state get the worst possible outcomes. You all need to do better. Prioritize us, not the industry. Thank you.
Thank you. We now will hear from Jan Rose.
Thank you, Commissioners. I, too, requested a moment to speak about the egregious nature of the remediation fraud committed on this commission, on the citizens of Colorado, on the state of Colorado. I dare say if this had been a commercial operation spanning hundreds of locations, there would be a federal case about it. I dare say that people would be charged for fraud. There clearly is significant financial profit and mismanagement in the case here, both on the part of the third-party contractors and on the part of the oil and gas operators who have, I might just offer, recorded record profits for the last couple of years. So it's not exactly that we'd put them out of business were we to associate the appropriate fines as determined by regulation. I expect further outcome from this proceeding. A $7.7 million fine is wholly insufficient. Additionally, much of the fine benefits the industry rather than the affected communities. That seems egregious again. So I look forward to the commission taking further action. I also want to point out a couple of other cumulative impacts over and above the idea that hundreds of remediated sites are hanging around primarily in the Denver-Julesburg basin, where most of the residents of Colorado live and are exposed to all the toxic chemicals in our soil and air. We also have a situation where the statutory requirement to use recycled produced water is decreasing along the Front Range, and a statutory requirement that it increase in this calendar year. So I look forward to the commission denying permits that are not using the appropriate level of recycled produced water in order to bring the DJ Basin up to the standard required by law. And finally, I request detailed information on the truck traffic. The cumulative impacts report outlined 3.3 million truck miles, virtually all diesel trucks with high levels of particulate matter, presumably moving fresh and produced water and fracking sand on and off drill pads. The bill requires that those transportation emissions be broken down into freshwater trucks and produced water trucks. I'd like to see those details, please. I look forward to working with the community liaisons to acquire that information from you as stipulated by law. Thank you for your time. Please do your jobs.
Thank you. We now will hear from Christian von Woudenberg.
Good morning, Commissioners. My name is Christian van Woudenberg. I'm a directly impacted resident and a former council member for the town of Erie. In recent years, I have built a small business around the extraction and analysis of data surrounding Colorado's oil and gas industry. In March of this year, to understand the context of the $1.53 million fine paid by Chevron for the Bishop blowout, I conducted a careful analysis of each of the 536 enforcement orders settled between the ECMC and operators since 2014. For the enforcement orders before the Commission today, the total penalties are almost $11.6 million. That sounds like a strong enforcement response, but the proposed settlements include suspending $7.7 million for settlement inducement, with another $880,000 slated for public project funding. At the end of the day, the ECMC will collect less than $1 million in cash, or about 8% of the original total penalties. Depending on the operator, this amounts to a penalty suspended percentage between 60 and 88%. My concern is that the amount suspended in these enforcement orders is far outside the range established by more than 10 years of ECMC enforcement history. In reviewing these settlement orders, I found that suspended penalties have averaged 35% of the total assessed amount over the last decade. If penalties for the falsification of environmental data can be reduced by this magnitude, it raises serious questions about whether the Commission's statutory penalty framework functions as a meaningful deterrent or merely as a starting point for negotiation. The falsification of environmental data strikes at the heart of the ECMC's ability to protect the public. As someone who spends about 100 hours each month analyzing ECMC data, I know how much of the Commission's oversight framework depends on the accuracy of operator self-reported information. When that trust is broken, every spill report, remediation plan, and enforcement decision built upon that data becomes less credible. I'm asking the Commission to reconsider the unusually high suspended penalty amounts in these enforcement orders. If trust in the data is essential to effective regulation, then the consequences for deliberately undermining that trust must be substantial. Thank you.
Thank you. Next, we have Yvonne.
Hello, Commissioners. My name is Yvonne, and I'm speaking today as a resident of Aurora and as part of a community that has shown up over and over again to participate in your process. Today, I am angry because what communities are realizing is this. When residents miss a deadline, we lose our voice. When operators violate rules, submit false data, or fail obligations, they get another chance. Recent reporting and public enforcement actions revealed that falsified environmental remediation reports went undetected for years. More than 400 oil and gas locations were affected. Thousands of falsified data points appeared across lab reports, including altered soil and groundwater contamination data. In some cases, contamination levels were changed enough to support requests for site closure that otherwise should not have been approved. And now communities are expected to believe you when you say, trust the operator, trust the process, and trust enforcement later. But why should we hand over our trust? How do we trust SM Energy to operate next to the Aurora Reservoir when public confidence has been eroded? How do we trust the ECMC to enforce its own rules when what communities see is a combination of aggressive permitting and weak enforcement? You often tell us that OGDP approvals are based on your rules. Yet, when violations occur, communities do not see those rules enforced to their full extent. Communities are paying attention. We see penalties totaling 11.6 million, yet nearly 7.7 million was proposed to be suspended. And some of those companies may also receive extra credit toward penalties by funding projects instead of paying the full amount. Communities look at that and ask, after years of falsified data and public trust being broken, is this accountability? If falsified reports can persist for years before detection, how can communities trust that oversight is working? And what assurance do we have that current monitoring is catching problems in real time? If enforcement of violations is weak, then why should we believe that permit conditions protect us? Community opposition to the Sunlight Lawn project has been unparalleled. Thousands of comments, packed hearings, years of participation. You ask communities to trust the process and protect and participate in good faith. But if accountability disappears when rules are broken, people begin to question the system. And then at some point, people stop asking whether the system is broken and begin asking whether the outcomes we are seeing are the outcomes the system was designed to produce. Trust is built through accountability. If the ECMC wants communities to believe your rules protect health, safety, welfare, and the environment, then enforcement cannot feel symbolic after public trust has been broken. Show us that your rules are not just conditions of approval. Show us that they're willing to enforce your rules consistently and aggressively. Thank you.
Thank you. Brian Matisse is next.
Thank you, Commissioners, for the opportunity to speak. I'm Brian Matisse. My comments apply generally to all of the proposed administrative orders by consent before the Commission. I am deeply concerned that approval of these consent orders will further erode public trust in the ECMC and reinforce the perception that the Commission is protecting the oil and gas industry rather than the people of Colorado. The Eagle and Tasman data falsification scandal is one of the most serious environmental data integrity failures in Colorado history. ECMC has identified more than 3,500 falsified data points affecting over 400 oil and gas locations, with intentional falsifications submitted for at least 3 years. Yet to date, I have seen no criminal charges and no meaningful direct penalties against Eagle, Tasman, or those accountable beyond these notice of alleged violation actions. Respectfully, the AOCs are a trivial slap on the wrist and an insult to Coloradans. For example, in docket number 151, the base penalty under the statutory per day framework would be $7,072,000. That's if the penalties were applied on a per day basis, as the legislative statute says. Staff then applies a discretionary duration matrix that reduces the penalty by 95.5%, followed by another 20% settlement discount. Even that reduced amount is then abated by another 75% if operators merely spot check 2% of contractor forms 19 and 27. 2%, something they should already be doing. The result is a 99.1% reduction, leaving the penalty of only $63,963. For these operators, that's less than a rounding error. Most troubling, staff finds no aggravating factors, even though data falsification and a pattern of violations are clearly identified as aggravating factors in the Commission's own enforcement guidance. The operators argue that contractors, not them, committed the falsification. That is no excuse. Operators have a non-delegable duty to submit accurate data. If they choose to rely on contractors rather than doing it themselves, they remain responsible for the accuracy of what is submitted to the state. And if a contractor commits a violation or caused the violation, the operator can pursue that contractor for recovery. Meaningful penalties on operators will therefore reach the responsible contractors as well. For these reasons, I urge the Commission to reject these AOCs, require meaningful penalties that reflect the seriousness of the misconduct, and send a clear message that environmental data falsification will not be tolerated as a minor paperwork issue. Thank you, Commissioners.
Thank you. Natasha Leger.
Good morning, Commissioners. My name is Natasha Leger. I'm the Executive Director for Citizens for a Healthy Community, and I'm actually not speaking today on the enforcement matters in front of you. On behalf of the 18 signatories that submitted a letter to you on June 4th regarding discretionary guidance, want to thank you for acknowledging the letter and appreciate the process that you have put in place to address it. And we look forward to hearing Stephen Arouza's update on the work that we've been doing with the Community Relations Unit over the last year, and look forward to working with you on this issue as it moves forward. Thank you for your time this morning.
Thank you very much. We appreciate that comment. Lauren M.
Hi, can you hear me?
Yes.
Excellent. Good morning, Commissioners and public hearing attendees. Nice to see you again. I'm looking at your hearing for today, and 7 docket items are in regards to oil and gas companies violating Rule 207 and General Rule 602. Rule 207 says any report required by the Commission, the Director, or the rules must be timely filed, accurate, and complete. General Rule 602 says that the ECMC enforces Rule 602 to mandate strict training, supervision, and safety protocols for oil and gas operation and their contractors. I am part of a group of Colorado residents that continue to meet with you and ask that you do your job, that you hold oil and gas operations accountable. They must follow the rules, regulations, and not go outside the lines or break protocol. That the oil and gas operations must pay for the damage that they have already caused, and that they stop causing damage to our beautiful state and all the families that live here. Seeing how Crestone has falsified data on at least 404 laboratory reports that were made by Eagle Environmental Consulting and Tasman Incorporated, 55 additional falsified reports were discovered in April 2025, and another 5 were added in July of 2025. It is time to start taking your job seriously and do not allow these operators to squeeze all the oil and gas they possibly can out of our beautiful state while depleting our most vital resources: clean air, clean water, and a clean environment, both for the people that live here and the animals that live here. Jeff Robbins, today you said that the ECMC does not change the rules of the game. Yet I have an article from The Guardian that was written on June 2nd of 2026 that says there are thousands of dirty oil well sites in Colorado. The state gave oil firms a $1 billion pass. Part of the article says that, but the companies also own more than 14,600 plugs wells where cleanup was never completed. Colorado regulators never requested security deposits for these sites. It further goes on to say state regulators can request more collateral for these cleanup projects, but they never did. The article continues, by law, the companies must remediate pollution and restore the land, but reports pulled from the Colorado Oil and Gas Information Systems database revealed that the big three, Civitas, Chevron, and Oxy, Civitas is also known as Crestone, allowed many of these dirty and environmental damaged sites to languish for years, or in some cases decades. Since 2019, the ECMC has had broad power to ensure compliance, had the agency simply followed its own protocols. In 2024, the regulator said contractors for all 3 companies had falsified environmental paperwork at hundreds of sites, including over pollution levels in water and soil, a situation the companies and the commission say they are investigating. But even then, the ECMC still did not use their power to increase the big 3, Chevron, Oxy, and Civitas, financial assurance totals. After Senate Bill 181 passed, the state's governor, Jared Polis, called Senate Bill 181 an opportunity for ECMC to uplift Colorado as a model for the nation. I guess my question for you is, are you being a model for the nation? Are you holding oil and gas operators accountable? Are you fining them when they deserve to be fined? Are they having to clean up their projects in a timely manner and do it to the full extent that they are required to do? At the end of the article, it says that ECMC has collected just over $146 million in bonds to plug wells from the big 3, Chevron, Oxy, and Civitas, since Senate Bill 181's 2022 enactment. That amount, which also covers the company's roughly 12,000 active producing wells, only represents 7% of their total cleanup costs, according to the conservative estimate. Again, ECMC, I want to believe that you're good people. I want to believe that you want to do the right thing and that you want to do what's best for our state. You need to do it. Now is the time. Thank you.
Thank you. Mr. Thomas, do we have anybody else that has signed up for public comment?
We do not, Mr. Chair. That concludes public comment today.
Okay, let's move to consent agenda. Does anyone have questions on consent? We have a motion to approve consent.
So moved.
Second.
Motion and a second. All those in favor signify by saying aye. Aye.
Aye.
Aye.
Any opposed? All right, next we're going to hear from Director Murphy on the commission review of administrative orders by consent. Let's take 9 minutes or so and return at 9:45, and then we'll take that up. Welcome back. This is the Colorado Energy and Carbon Management Commission, our Wednesday, June 24th business agenda. We now will take up a presentation from Director Murphy, Commission Review of Administrative Orders by Consent. It is dockets ending in 0150, 0151, 0152, 0153, and 0155, and 0156. So with that, we recognize Director Murphy. Good morning.
Good morning. Thank you, Chair. Thank you, Commissioners, and thank you to Coloradans who are tuned in. I know we've heard some public comment related to this, and I want to kind of provide some perspective from our side about where we are and why. And so I'm here to briefly discuss the AOCs that are before the commission. I request that you approve them, which would make them a final order of the commission. And I want to acknowledge that this is an unprecedented incident. And so, given that, I'm here to kind of provide an overview of why we're here and why the AOCs came straight to the commission instead of going through a hearing officer. I think on this issue, it was important to be transparent and put this before you directly so that for the benefit of all of our stakeholders and your own decision-making and awareness. So before you are thoughtfully crafted and reasonable AOCs that staff believes address the underlying violations that occurred while balancing out the fraud that occurred by a third party. Work remains to be done in addressing the full extent of the issue. That work is ongoing, and staff, including myself, agree that approval of these AOCs is an appropriate next step that will bring ECMC's enforcement related to this work to a close. We recognize that there is ongoing work to be done in the field with surface owners, with local governments, and with the operators. I think some factual background that's important about this incident to refresh everyone's memory. This incident was brought to us in the summer of 2024 when Eagle Environmental Consulting and Tasman Geosciences, third-party contractors to oil and gas operators regulated by the Energy and Carbon Management Commission, identified discrepancies in laboratory analytical data related to certain aspects of remediation project lab reports. I want to reiterate that these discrepancies were self-reported by the contractors as well as the operators. And it remains incredibly disappointing to me that environmental professionals employed by third-party contractors would behave in this manner. That behavior, however, is beyond the scope of what this commission regulates from my perspective. And I would also acknowledge that we have referred the behavior or the matter for criminal investigation. And that is something that we reported to you in November of 2024 as well. These discrepancies were on ECMC Form 27s, which for folks who don't speak our form language, I barely do, are our site investigation and remediation work plans, and some Form 19s, and those Form 19s are spill and release reports. The discrepancies pertain to some analytical data concerning soil, groundwater, inorganic, and organic contamination. As I've said previously in my updates to the commission on this matter, the disturbances from the oil and gas operations at these sites was not changed by these discrepancies. However, the discrepancies may affect the degree of remediation work that remains to be done to clean these sites in accordance with ECMC's expectations. And to be abundantly clear, the expectations of cleaning these sites is unchanged. I would also note that all 6 operators voluntarily disclosed this issue to ECMC and have undertaken efforts to address not only the lingering impacts, but also what gave rise to an opportunity for the discrepancies to be submitted. So turning now to the NOAVs specifically, as we announced on July 23rd, 2025 in the press and at a public hearing, following an extensive and detailed investigation, ECMC staff issued NOAVs alleging the following violations. Rule 207, which requires accurate and complete reports from operators, and Rule 602, which requires training and supervision of contractors. Following the issuance of the NOAVs, consistent with our process, ECMC enforcement staff spent time negotiating with the operators and their attorneys. This was a significant lift for our enforcement teams, our technical staff, and I did have a hand in some of it, but the water was really carried by staff. And I am grateful for the time that they put into this. I would note all of the AOCs were signed in May and early June of 2026. And I'm here to make sure it's clear that these agreements represent the position of all ECMC staff, including myself. And again, given the unprecedented nature, an element of fraud by an employee or two of a third-party contractor, I am satisfied that the AOCs before you, including the suspensions and public project offsets, are an appropriate resolution to this particular set of circumstances. A key element in this overall situation is addressing the need to ensure our data is accurate and complete by pursuing the underlying violations with the respective operators, while simultaneously understanding that fraud occurred here is unprecedented. And thankfully, we are unaware that it's ever occurred at ECMC or perhaps in Colorado before. We continue to expect accuracy in the information filed with ECMC and believe that these AOCs and the numerous data verification steps that staff has taken since will only improve the future reliability of ECMC's database. In addition to changing our processes in terms of how we intake information around from labs and contractors, we have also undertaken an independent review of information submitted to us, and we are continuing to look at how we can process improve in this space. I'd like to turn now to the AOC itself. Before you today are 6 AOCs wherein the operators have agreed to a penalty corrective actions, and 3 of the AOCs fund certain public projects. I'll discuss each briefly in turn. First, focusing on the penalty, the tables outline an agreement as to the 2 violations I noted previously. Each rule classification was established in the enforcement policy, and staff did not deviate from that. Given the threat of significant adverse impacts that resulted from the falsification, we did apply a moderate impact factor to each violation. The Rule 602 penalties were assessed from the date the first falsified data form was submitted to ECMC and an end date of when the operator disclosed the falsification to ECMC and actually began correcting the information. The Rule 207 penalties were assessed for each individual falsified form submission. The start date of the violation is when the first falsified form was filed, and the end date is when the operator voluntarily disclosed the third-party contractor data falsification actions. And in the situations in which a form was filed after the date of disclosure, the start and end date is considered the date of filing. I want to turn now to suspension, which of course has gotten an appropriate level of attention, but I want to articulate a couple of things. Suspensions were applied based on the operator's internal performance of an audit of forms that were submitted by their consultants, the operators performing quality control spot checks on future Form 19s and 27s, and providing a standard operator procedure for contractor training and oversight to staff no later than 30 days from the effective date of this order. We think these steps are critically important for different reasons. 1, to verify that we understand the scope of what has occurred, and 2, to prevent this going forward. Again, we believe that this is unprecedented and we hope it will be a one-time incident. But nonetheless, we have required steps both of operators and from our own staff and review process to preclude it going forward. Turning last to the public projects, 3 operators are contributing to specific public projects. The public projects to highlight are 1, focusing on providing funding to Energy Outreach Colorado, which will help support transitioning up Coloradans from domestic wells into a more safe energy supply. And in addition, Noble, pursuant to its proposed AOC, will provide $150,000 to support a geothermal summit solutions later this fall, and $130,000 to the Groundwater Protection Council to invest in a specialized environmental software and data management tool for managing laboratory analytical and field data. So at this point in time, I've kind of overviewed what brought us here, the terms of the AOCs themselves, and I do want to do a quick overview of procedure. So once we have reached an AOC, enforcement staff files the cases and receives assigned docket numbers. And so I want to note that, these have docket numbers 150, 153, 155, 156. 154 was inadvertently assigned but was not used, just to understand why there's an out of sequence piece. And with the operator's consent, we removed these matters directly to the commission instead of pursuing review by a hearing officer. Again, we think that is critically important given the importance and visibility of this particular issue, as well as its unprecedented nature. With that, I want to close with a couple of thoughts and remarks. Of course, I noted my gratitude to staff, but I want to reiterate it again. So many folks have spent so much time on an unfortunate incident, and staff will continue to work on the remediation efforts, which are critically important and ongoing. And all of this work is what has led us to get the AOC before you here today. I want to reiterate again that we have instituted our own process checks to prevent this from happening on a go-forward basis, and we are continuing to evaluate data submitted by operators other than those before you to ensure that if there are other instances, we are aware of it. I would note again that this has been referred for criminal investigation. That again is outside the scope of our review. And I want to close with kind of one final piece, which is maintaining the integrity of environmental data submitted to ECMC is essential to protecting public health, safety, welfare, the environment, and wildlife resources. These enforcement actions reflect the seriousness of the violations and the importance of ensuring regulatory decisions are based on accurate and reliable information. With that, I would ask that the Commission approve Order 1V 1033 in docket number 150, Order 1B 1034 in docket number 151, Order 1V 1035 in docket number 152, Order 1V 1036 in docket number 153, Order 1V 1028 in docket number 155, and Order 1V 1041 in docket number 156. And I'm happy to take questions. Staff is also available if there are questions that I'm unable to answer, of course. And with that, Chair, I would return it to you.
Thank you, Director Murphy. I'm going to dig into something that came up with the public comment this morning, and we've heard from legislators and others. Our enforcement process is meant to achieve the goals of continued compliance with our rules and deterrence away from not complying with our rules. And the approach by you and staff on these AOCs is this recognition that there were third parties, a recognition by the operators that, kind of fessed up that we've got this problem and we want to work with the commission, a imposition of penalties, and then, as you mentioned, the quote, suspension of penalties and the dealing with good projects. Can you dig a little deeper into how it is that this multifaceted approach is the best for the state of Colorado, given the extraordinary circumstances that are occurred here, and given the fact that it is true that, we could just take a 2x4 and just hit them up the head with penalties and penalties and penalties, but you're not suggesting we do that, and instead it's more nuanced.
It's a great question, and to be really direct about it, to me, the most important thing and the most important place to focus resources is getting the remediation projects cleaned up. Us collecting penalties is an important demonstration of enforcement, and it's distinct from actually doing the work in the field. And so I think that in part, by providing suspended penalties, which require ongoing and future commitments to preclude this going forward, is an important tool that is represented and I think aligns both this commission's enforcement authority with the work with future compliance. So I think that's a very critical component that is easy to miss. We do want to encourage people or operators to disclose situations like this so that we can get to resolution quickly. And that is an important component of this conversation. And fundamentally, these are significant fines as you look across our authority. So I think collectively, and given again the fact that we have third party, employees of third parties who've made decisions that don't align with professionalism, in my opinion, is really an important factor as well. And so it is complex. It's why I've been more involved than I typically am with enforcement matters. And I think that it also has helped us think through how we can improve our systems. And we're taking that to heart as well. And it will continue to be integrated in the work that we're doing to update our data management system, to update our forms, and to continue to evolve and refine how we collect and manage data.
Thank you. Others with questions of the director? Commissioner Messner?
Thank you, and thank you, Director Murphy, for the overview and the information. I had just a couple of questions, and I think just some of it's to provide clarity. So we've got two different discretions that are applied here. We've got the 20% discretion reduction, and then we've got an additional reduction in the suspended penalties. I wonder if you could talk about the difference between the 20%, and someone from staff can do it as well, but the difference between the 20% discretionary reduction and the additional suspended penalty, and whether or not there's consistency with what's being applied here with other NOAVs or AOCs that come before the commission. And then in addition, again, to provide clarity, the specific findings that are proposed in the order that kind of rationalize or tie to the need or the desire for these discretionary reductions and suspensions.
Thank you for the question, and thank you for digging in. I would like to ask Elias to elevate Jeremy, as he's better suited to kind of answer the broader question as you look across different enforcement matters, because it is a different use of our suspension authority than we have typically used. And so in that vein, I would offer, the 20% is we want to encourage disclosure. That is important to us. I think that is fairly consistent with what we've done historically. On the remaining piece, the bigger piece, right? This is where we are looking at the scope of this issue, right? We're talking about hundreds of sites. And again, our focus has been on getting them cleaned up. That's the top priority. And trying to normalize that, recognizing the intervening factor of somebody performing what appears to be fraudulent to me again. Again, these are my opinions. I'm trying to be careful about representing or characterizing behaviors that I'm not responsible for managing, but are highly problematic at a minimum. So with that's kind of the overview. Hopefully we can get Jeremy elevated too to talk about kind of how it fits together, and there he is, terrific. So I'll turn it over now.
Mr. Farron?
Good morning, Commission. Jeremy Farron, Enforcement Manager. Commissioner Messner, if I heard your question correctly, you had sort of two pieces to it. So a description of what the settlement discount is, which is very common in AOCs. And that is a discount somewhere in the 10 to 30% range for agreeing to the AOC and avoiding the need to have a contested hearing in front of the hearing officer of the commission. That's pretty consistent across most AOCs. The second question, if I understood, was sort of describing the suspension piece of it. And that, I think, Director Murphy has touched on, given the nature of these particular violations and the statutory mandate to get a penalty that is appropriate to the nature of the violation. That's where the suspension was applied, given the self-disclosure, given the conduct of the third party. Given what we're going to see as corrective actions in these AOCs, that's where a suspension is appropriate. Suspensions occur in AOCs. They're not as common as settlement discounts, but they do occur. And so I think you had two different factors here that resulted in sort of the final number, but the penalty calculation was consistent across all the operators, right? We felt that was important to have that established, and then from there using some of these levers to get it so that it was appropriate to
the thanks. I want to dig into a couple pieces there. So my understanding is that I understand the discount, and so that seems consistent. The settlement discount, I think we see that in almost every single AOC, almost every single AOC that comes before us. And then the suspended penalty, I think I'm hearing you say that the findings are the things that kind of rationalize that are that the operator had come forward voluntarily with the violation, and then two, that it was a third party contractor. I think there was other findings in there talking about the ultimate impact associated with the violation as well. And I think maybe if you could dive a little more into that, because I think that ends up being an important piece. And then I do have a question for the second finding, which is that it was a third party. I mean, really, Rule 602 is a rule regarding third parties, right? And so this was a violation of Rule 602. And so I'm struggling a little bit with the finding regarding that this is a third party, because it's clear in Rule 602 that the operator is responsible for all third party contractors, and that is the violation that occurred, right?
Yeah. Sorry, I think there were maybe a couple things there. One was the impact associated with this, and I think Director Murphy touched on that, which was that, these were spills. They were in the process of being cleaned up. They might have been closed early, but this documentation did not result in impacts associated with these remediations, right? We were aware of them, we're monitoring them, we're going to make sure they're closed in accordance with our rules. Sorry, there was something that preceded that I think I missed. I got your last one, which was 602, but what was the one that preceded that?
No, I mean that was the question that I had asked, was that, and then the other piece being, the Rule 602 violation was an actual violation of the operator managing third parties, but it seems like the finding that ties that to a suspended penalty is that it was a third party operator or a third party, contractor. So I'm trying to understand, because it's important to me that we tie findings to any rationalization of suspended penalties, but I'm struggling to tie that one because it is a Rule 602 violation with the finding that it's a third party contractor. And so there should be some consideration given for that.
And it's not just that factor, right? So you take the calculated penalty, you attempt to make it appropriate to the nature of the violation. And so the suspension was applied for a couple different reasons, including the fact that it was a third-party contractor, right? No additional impacts, the fact that it can be unsuspended for years into the future, right? Like that's a pretty helpful tool for enforcement to have. If this happens again, we can unsuspend a penalty without the need of returning to you folks. So that's a pretty helpful offset as far as we're concerned. The fact that they were self-disclosed. So it's more than just that single factor as a justification for the suspension. So there's a couple different pieces that result in, what we thought was an appropriate suspension. And the unsuspension piece of it is, like I said, a pretty big one. Sorry, additionally, some of those corrective actions include actions by the operators that are not explicitly required by the rules. And so we've offset some penalty dollar for them doing some additional work, the spot checking, the quality controls, that sort of stuff, into the future that they're not explicitly required in the rule. Sure, it would be prudent for them to do it, but now we have it in there. We can ask for this information. We can unsuspend a penalty if they're not doing it. So I think we sort of got something for that offset.
Okay. And understanding that continued compliance in the future is really an overarching goal here. And so I understand and appreciate that.
Yep.
And I think in response to public comment as well, is this level of suspension, I guess from a percentage standpoint, is this unique? Is it not unique? maybe talk a little bit that as far the across the breadth of AOCs that come before us. Is this level, this percentage of suspension in line with what often happens or not?
I think it's probably safe to say it's atypical. This was a larger suspension, given all the factors we just discussed. I'm a little curious. Sorry, I wrote down his name, Mr. Van Woudenberg. If you can send me your data analytics, I would love to see it, because I think he was conflating settlement discounts with suspensions and lumping them all together and coming up with a number that I'm not sure is accurate. But to answer your question, the settlement discount is in line with multiple previous AOCs. The suspension was probably larger than typical, but within the realm of sort of average over the last few years, particularly with operators that we revoke their right to continue operating. There's usually suspensions applied in those cases too. So I'd be curious to see his numbers. I can't off the top of my head tell you whether or not, it's within the bell curve of normal. So
Great. Thanks for answering my questions.
Other questions for either Director Murphy or Mr. Farron? All right, seeing no further questions, you guys stick around. You may have questions, but we do move to deliberations. We've been asked by the director that we approve the AOC dockets that are before us. We've had a chance to ask questions as to how they were derived. And at this point, it's up to commission to make a determination as to whether it should approve the AOCs as presented to us. And we don't generally take comment from the operators or their lawyers, just for the record, on an administrative order of consent that just comes to us. A lot of times those are even on consent agenda. Anybody desire to comment, deliberate, think about it? Commissioner Messner?
So I appreciate all the work that's done on this, and I do believe that this is a unique situation. And so sometimes unique situations require, unique solutions. And so, I have asked questions about enforcement and AOCs and application of the rules, for the entire time I was a commissioner. And I always appreciate the consistent and thoughtful information that's provided by the enforcement staff on how they come to the conclusions that they do and how they apply the rules. And there's very specific guidance and information in the statement of basis and purpose and in the rules on how enforcement is handled. And I do believe very much so that the ultimate goal here is long-term compliance with the rules. You always have to acknowledge that there was a lack of compliance at some point which caused the NOAB, which ultimately became the AOC. But moving forward, ensuring not only compliance by the violating operator or operators, but by the industry as a whole of our rules, within the state moving forward. And I think that the approach to that can't always be a stick. The stick is certainly an important tool that is available to the commission in applying our rules and enforcing our rules. I think there is, more creative and effective ways that include elements of a stick and elements of, more pragmatic approaches to ensure compliance moving forward than just the utilization of the stick. In this particular instance, I think it's unique because in applying the severity of the full application of the penalty as a stick, as I look at it pragmatically, would actually incentivize or encourage operators to not self-report situations like this because of the ultimate potential impact associated with it, but rather continue to hide any potential missteps that have occurred, to not have to address the full stick. Now, the other side of that is that it may incentivize operators to not make these mistakes again, but I think it's probably 50-50 in my mind as to whether it would be effective or whether it would be the opposite of that. And so I think looking at this pragmatically and then the application of both elements of a penalty, and it's important to note as we apply these, the kind of overarching reasonable and necessary elements need to be applied to this as well. And ensuring that the penalties that are being applied, are reasonable for the impacts or the violations that occurred. And, I think staff did a good job of, developing findings and showing how they think that this approach could be effective. I think, if I was doing it individually, I may have done it a little differently, but I also think that what is being proposed here could be an effective mechanism for ensuring compliance moving forward, which is ultimately my goal here, is to ensure that the data that is being provided, that ECMC is relying upon as far as making determinations for remediation and closure of spills and releases, and other parts of our rules that require, accurate data. So I think this is a pragmatic solution to a challenging situation that hasn't necessarily come up before. I think it is a reasonable solution, and perhaps more reasonable than full application of the penalty. I do wonder a little bit about Rule 602, but I think I'm okay not pushing that one to the point where we have to go and redo AOCs, because I think quick resolution of this is also an important factor. And I think the kind of ensuring of the internal processes within operators for verification of data and ECMC's ability to re-verify that data is also a really important element to this. And that any failure to comply with the AOC does immediately remove that suspension. And I think that also is an important piece to ensure compliance moving forward as well. And so those are my thoughts as I've reviewed the AOCs in a pragmatic way. And so appreciate the work that staff has done with this.
Thank you for leading off, Commissioner Messner. Others with thoughts? Commissioner Ackerman?
Yeah, I'll go next. Thanks, Mr. Chair, and thank you, Commissioner Messner, for leading off. And I think, like many others from our staff, from the commission, from industry, certainly from the public, as we've heard, have been appalled by this issue since it came to light. I remain appalled by this issue. I remain angry about this issue. Our job as commissioners is to consider, as staff does their job, and as companies address issues that come up, when our judgment needs to be employed, to be able to hold off until others have done their work so that we can make judgment. And that's a difficult seat to be in, and it's the seat that we've been appointed to. And in the end, we often refer to staff as, a whole when we're talking about staff, and our staff is comprised of incredibly bright and capable professionals, as Director Murphy has a habit of pointing out. And like the commissioners, they take their jobs and responsibilities very seriously. We heard from some public commenters today, as this issue is often raised, and I'll quote a couple of them here, as operators who outright lie. And so I appreciate Director Murphy clarifying the circumstances surrounding this case. There are mitigating factors. This was the same contracted company. There was voluntary disclosure upon discovery, as was pointed out. No discovered further adverse impact. We're able to address it and put processes in place to address this issue going forward. That said, I do agree with public commenter Brian Matisse, who said it's no excuse that it was a third-party contractor. The operators are ultimately responsible, and I very much appreciate staff's hard and diligent work on this issue, and I want to also recognize the involved company's diligent and deliberate efforts to rectify this issue. I'm sure they were appalled as well upon its discovery. And I believe that they would have disclosed this issue regardless of whether they believed entire penalty assessments were going to be imposed or not. The history, at least the short history that I've had with these companies, has largely been one of disclosure. So all that said, the thing that I keep coming back to is this is absolutely not a standard violation that we see in the course of business. It's not a standard industry violation. This is fraud. And while this fraud, and I'll directly call it environmental fraud, upon the public trust was committed by one consulting entity, ultimately the companies employing that contractor are, and they will continue to remain accountable in the future, and they must take steps to ensure their own compliance. And it's been difficult for me to see that there aren't already procedures in place at the company level to ensure that quality control is taking place at every point in their business, including this point. And some of the public comments today have reflected my thoughts on this issue since it came to light, particularly those that were submitted by Christian Van Woudenberg, Yvonne Yap, and Brian Matisse. This has been a deep violation of the public trust through purposeful, not negligent, but purposeful fraud, rather than what we usually see over the course of business, which are oversights, unintended incidents, even some negligence or improper training, all of which we address, in my opinion, staff addresses admirably. So I, like our commenters today and others, I'm very angry about this issue. And I know that's the case with our staff too. And they've done a great job of being professional despite seeing this violation of the public trust and working towards resolution. Admittedly, my first instinct is to reasonably discover, discuss, address, and diplomatically resolve difficult issues, as staff always does and has admirably done in its proposed AOCs. As I also agree, the top priority here, as pointed out by Director Murphy, is fixing the issue ultimately. And so to that point, I generally agree with our historic approach to violations of our rules. Our focus is first and foremost on fixing the problem. We incentivize, as Commissioner Messner pointed out, and use a stick, and that's often appropriate. And in doing so, our intent is to work together with violators to ensure violations, which are, again, normally either inadvertent or unforeseen or occur in the course of imperfect entities and people working to do their best to ensure that they're fixed and that they don't occur again. And so in so doing, as Mr. Farron very clearly pointed out, it's very common in AOCs, I think in all AOCs that I've seen, to discount and or suspend a portion of penalty assessments in response to a violating operator's proactive actions, conduct, and agreement. As staff diligently negotiates, these are the steps that you must take in order to remain in a penalty assessment suspended state. But it comes back to me that the bottom line here is that this is an egregious, deliberate falsification of report data. It constitutes deliberate fraud against the citizens of Colorado and against Colorado's environment. As the commissioner sits in the Wildlife Environment and Remediation seat, and as a former natural resources law enforcement officer, I've been put in a lot of difficult circumstances over the years. And there are times that I believe full penalties for penalty's sake are entirely appropriate. And I do recognize this was the act of one consulting company. I personally am, as one commissioner, am not inclined to give any quarter at all to any involved party on a violation of the public trust of this magnitude associated with deliberate intent and deliberate falsification of data. Many people have worked really hard to make Colorado's approach to oil and gas development the most protective in the nation, myself included. And again, I believe that we are that. And I think evidence has pointed that we are that. And there are all manner of assertions made in public comments and others that we don't take our job seriously. I think objective analysis of the evidence is exactly the opposite. I think this incident has also injured the oil and gas industry's public license to do business as a whole in Colorado. And as evidenced by some of today's comments, as well as the many references to this issue that have arisen during many OGDP hearings since the discovery of this issue. I believe Coloradans are angry about this, as am I. And so while I appreciate staff's approach on this issue, and I really do understand the road that they went down, I understand how it correlates with how we normally handle AOCs. You know, as part of my previous life, I went through police academy training, and one of the foremost things that they teach people is, you know, either hit them hard or, fix the problem, right? And it's not often that you do both. But for the reasons I've pointed out, it's difficult for me to believe that our normal approach here is warranted. And rather, I believe that this is a unique and anomalous and egregious and, to me, a preposterously unethical violation. It's just not normal in the course of business. And I think it results in a rare instance in which I would support total fines being enforced without settlement, in addition to continuing to rectify the issue and ensure it doesn't happen again. I do take into account that the human nature might be inhibited by future from future disclosures by such an action. That said, the chickens always come home to roost. Hiding things, as our parents all taught us, only leads to prolonging of the issue and will ultimately be resolved. My personal opinion here is to apply the entirety of the penalty assessments. I would be open to discussion of reductions that are slight based on certain circumstances if we had that. I think the percentages that we've reduced in what I think is a very anomalous issue, because we've used our normal course of business appropriately, is not appropriate here. And finally, while I'm not aware of specific details of ongoing law enforcement operation, because that's the intent of ongoing law enforcement operations, they're ongoing and details aren't shared until they're resolved. I, as a commissioner, encourage appropriate law enforcement investigators to continue to pursue diligently and prosecute this fraud to the fullest extent. And that's where I stand, Mr. Chair. Thanks.
Appreciate my fellow commissioners' comments. They're all very appropriate, I think. Others with comments? Commissioner Cross?
Thank you, Chair, and thank you, Commissioners Messer and Ackerman, for leading off. I'll start by echoing what Commissioner Ackerman said. I think this abhorrent violation of our rules is extremely troubling. I think the light that it paints operators, third-party contractors, then is appropriate, even knowing that this is a limited circumstance as to what's happening. And I'll say that I think that one of the things that stuck out to me during a lot of the public comments was the references to we haven't seen the criminal investigations yet. And I concur with Commissioner Ackerman. I think that I hope that some sort of criminal action is taken against those third-party contractors that acted improperly. but unfortunately, it's not something that we have the authority to do. And I think this would be very different if the legislature had granted this authority. But we are bound by our legislative mandate. And so I think that while I agree with many of the comments that both my fellow commissioners have made thus far, I do think that the mitigating factors, the fact that this was a third party, and also especially the idea that we want to encourage future disclosure is important. I think one of the things that's come up a lot recently, kind of again, it's not new arguments, but it's some arguments that have been made previously is with relation to the financial assurance. And the way we set up our financial assurance is to get some upfront costs, but to also encourage that the cleanup, that the plugging and abandonment happen along the way. Just forcing everybody to pay 100% upfront is not going to encourage that. And then we take appropriate actions based on the productivity, the likelihood of wells being orphaned as something that mandates how much should be paid upfront. And so I think one of the important things here is making sure that our ultimate goal, and that's the protection of public health, welfare, environment, and wildlife resources, is met. And I think this is appropriately met by hitting these operators with fines, even though it was not their direct actions, and making sure that they continue to spot check these contractors and make sure that this does not happen again. I do think that the continued enforcement is an important factor here. And I'll just say I agree with Commissioner Messner. I think that I do go back and forth on it kind of being a 50-50 on whether this is going to be something that encourages future disclosure. But I think ultimately I would rather spend our agency resources not involved in adjudicating hearings before us, but instead making sure that our enforcement officers can turn to additional matters that come up as they come up, and making sure that the issues that did occur and were disclosed will continue to be adhered to. And so I will be in favor of the AOCs.
Commissioner Oath?
Thanks, Mr. Chair, and thanks to my fellow commissioners for your comments so far. I think it's clear from what we've heard from public comment, from the comments from Director Murphy, and certainly the comments from commissioners thus far in deliberations, how serious this situation is, and particularly that there are violations here that were not of a failure of a system, right? But were a decision by individuals to purposefully commit fraud, and that is very serious and very, fortunately, very, very unusual. And so that is certainly weighing very heavily, I think, on me and on all of us here. In addition, I think about the serious nature of violations in a number of aspects, and one is this, where there's this very serious situation where the impacts ripple out in terms of both public trust and our own trust, as regulators, because we operate within a system that has to rely on data that is submitted to us, and so that this is really impactful. On the other hand, another factor that I think comes up in some cases, but is not present here, is that a violation really has resulted in a direct impact to increased risk or adverse impact to public health or safety. So that kind of weighs in the other category here. I think in general, agree with many of the comments made about the importance of enforcement actions. I think there are a number of things that are very important to why enforcement action is critical. It's one, in order to get operators back into compliance as quickly as possible, but also to ensure that we're holding operators accountable, that our actions operate as a deterrent, and to ensure that when violations occur, non-compliance occurs, that we put in place systems so that that does not happen again. And I'll be honest with you, I'm struggling here. I came into these deliberations after reviewing the materials, after listening to public comments, after listening to Director Murphy and Mr. Farron speak and answer questions. I came into the deliberations thinking that these AOCs really do strike the balance of all of the factors. I am really sympathetic to Commissioner Ackerman's comments. I think this is what deliberations is about. And so I find myself in a situation where I'm kind of just continuing to contemplate. So I've just shared, I guess, my initial deliberative thoughts. So I think that's all I have to say for now.
All right, thank you, fellow commissioners. I guess at the end of the day, the folks that committed the fraud are not making this easy on ECMC, commissioners on ECMC staff, on ECMC's enforcement team. Having said that, I'm more in the camp to approve the AOCs as presented because I do delegate, or I don't delegate, but I accept the subject matter expertise of our longstanding enforcement team and of our director in terms of how they go about dealing with a particular situation that is extraordinary and not in line with what we're used to seeing. And so I will continue deliberations, but at this point, I appreciate what I've heard from Commissioner Messner and Commissioner Cross. I appreciate what I've heard from you, Commissioner Ackerman, and you, Commissioner Oath. I don't think this is an easy decision one way or another, but I do believe that at the end of the day, I will defer to the expertise of our AOC team, our enforcement team, and their contemplated idea about the best way to go about working through this. I think it does capture, and this was my question early on to Director Murphy, sort of the nuance between just penalties versus penalties and yet making sure it doesn't happen again, and yet keeping their third-party folks honest, and yet doing good things with some of the penalties through some of the projects that are contemplated that I know were negotiated extensively. And none of that would be viable, doable, et cetera, if we merely reject AOCs and then go down the path of penalties or nothing. So those are my deliberative thoughts. I'm happy to continue the deliberative thought prospect here with other commissioners. We could also take a break. We could, it's up to us to determine what's the best step for the state of Colorado with the guidance and advice of Director Murphy and Enforcement Officer Farron. Commissioner Messner, you raised your hand.
Thanks. I wonder if we could, it's okay if we need to take a break before this, but I wonder if we could ask the AG Boudreaux kind of decision-making options, and at least in my mind, it seems like we could, approve the AOC as presented, deny the AOC as presented, or offer deny the AOC as presented and move forward with, full application of the penalty, or something in between. And so maybe some clarity on that would be helpful in the decision making.
AG Boudreaux, are you ready to answer that, or do you want some time?
I'm ready.
Go ahead.
So the commission essentially has three options here with these AOCs. Option one would be to approve approve the AOCs as they've been presented to you by staff on the hearing officer's recommended order. No, excuse me, just presented by staff. So option 1 is approve the AOCs as presented. Option 2 is if the commission does not approve the AOCs, you can remand the matter to the director for further proceedings, and the commission can provide guidance to the director on what terms you'd like added, changed, removed. That could lead to commission approval of the AOC. And option 3 would be if the commission does not approve the AOCs as presented, to instruct the hearing officers to set the matter for contested evidentiary hearings. And then as my own recommendation, I would recommend either options 1 or 2, because that would option 3, sending it back to the hearing officer, doesn't give staff the opportunity to renegotiate the AOC in accordance with your direction. But ultimately, you have 3 options: approve the AOC as presented. Option 2, send it back to the director and the operator with guidance on what it is you'd like to see added, changed, or removed. And option 3 would be to send the matter back to send the matter to the hearing officer for a contested evidentiary hearing.
Good question, Commissioner Messner, and good answer, AG Bedreau. Thank you both. Commissioner Messner?
Could I'd love 10 minutes just to noodle on this for a second. If that would be amenable to the other commissioners.
When one commissioner asks, I generally grant. Let's take 10 minutes. Let's return at 10:53. All right, commissioners, we are back on the AOC matters that are on our agenda. It's Wednesday, June 24th, and it is 10:54. We took a short break to allow commissioners to gather thoughts. We are in the deliberation stage of the AOCs that have been presented to us with a recommendation of approval from staff. We've all deliberated a little bit, and we were going to deliberate a little bit more, I think, at this point in time. We've heard from the AG Bedreau that we can approve, we can send it back with direction to staff to continue to negotiate a different AOC or a more aggressive AOC or whatever we think is appropriate. But I think if we're doing that, the more direction, the better for staff to continue to work through these matters. And then the third option, which I agree with AG Bedreau, I don't like it as well, as to tee this matter up for a contested hearing. So that's where we're at. I don't like option 3. I'm comfortable with option 1. I could discuss with my fellow commissioners something along the lines of option 2, but I really would want us to get more into the details of that, because we would be going against what we've heard from our subject matter experts in terms of what's the right approach. And this is very novel for us. And so I want to honor, at least this one commissioner wants to honor staff's approach to what they've done so far here. I know it's been a pretty heavy lift to get to this point to begin with. Others with deliberative thoughts. Commissioner Messner?
Thank you, Mr. Chair. So I took a second and again reviewed the rules that were violated. And I think I indicated in my initial deliberative thoughts that, I think there's lots of different approaches to take, pragmatic approaches to look at both the utilization of the stick and other ways of encouraging compliance. And, and I also asked some questions prior to deliberations around Rule 602 and the applicability of that as part of reduction or suspension and penalties. I think that there are pragmatic solutions to this. I'm not sure, and I'll ask Commissioner Ackerman a question, whether he's more inclined to go to an evidentiary hearing or whether there's some openness to looking at other direction for modifications of the AOC. I do see some benefit in a full application of of the penalties that were imposed for Rule 602. As I'm not sure that that warrants suspension because, or even settlement discounts, because it is really the root, I think, of the problem here is that the operator did not oversee or did not train or did not manage their third-party contractors in a way to ensure compliance with ECMC rules. I think that in turn caused some of the violations of Rule 207. And I think I still have some appreciation for the self-disclosure of the operator, particularly once they found out the violations, and quickly addressing and developing protocols for ensuring that there is accurate data that is included in those forms. I think, to me, there's some room to encourage compliance with the operator in the penalties that are associated with Rule 207, but perhaps not in Rule 602. So I put that out there just as a thought, as we look at this, depending on where other commissioners land. I do also acknowledge and still believe my initial comments that, it was a pragmatic approach that staff took. I give it a 50-50 chance of being successful with overall compliance versus, imposition of the whole penalty. But think there may be some opportunities to look at it slightly differently, as I had indicated in my initial comments. So I throw that out there just as a discussion point.
Others desiring to weigh in? Commissioner Oath?
Thanks, Mr. Chair, and I really appreciate having a little bit more time to kind of think through this, and appreciate AAG Boudreaux laying out kind of the options in the way that he did. I would agree that I don't want to send this to a hearing officer for a contested hearing. I do think that for many of the reasons that have been stated, there is value working through this if we can. And that said, as I've had more time to think this through, while again reiterating and my sympathy for or agreement with many of the comments made by Commissioner Ackerman about the seriousness of the situation, I do, as I've had more time to think about this, I am comfortable with some suspension or reduction in penalties in this case, given all of the circumstances. And so I appreciate having more time. I am open to additional discussion, but could find that the AOC as proposed is something that I think I could be supportive of.
Thank you, Commissioner Oath. Others desiring to weigh in? Commissioner Ackerman?
Thanks, Mr. Chair. Just a response to Commissioner Messner's question, and always appreciate the opinions and insight of my fellow commissioners. And I think, absolutism in deliberations rarely has a place, right? And so, I'm always open to further discussion. I'm always open to, what we can do to further the mission of our agency and further the mission of resolving this issue. That said, I do remain in the boat of, I think, full or almost full imposition of penalty assessments remains appropriate here. And so I am significantly to the other side here, I think, of approval of these AOCs in their current forms.
All right. Well, let's try something. I would move, and this is not to cut off debate, et cetera. I just want to kind of keep us moving. I would move approval of the AOCs as presented. just to see if we can get to see where folks are. AG Boudreau, is that an appropriate motion?
Yes, Mr. Chair.
Do we have a second?
Second.
Okay, we have a motion and a second. Now there's an opportunity for discussion on the motion, or we could just do a vote and probably do a roll call. Hearings Manager Thomas, given that this is difficult and not quite sure the right answer for anybody on this front. Is there further discussion on the motion at this point? Commissioner Messner?
Just, I guess, to clarify my thoughts on this before I vote. I do appreciate Commissioner Ackerman's perspective and do think that, full imposition of the penalties is also an appropriate path forward. I think if there was some appetite to look at significant or full application of the penalties associated with Rule 602 and application of suspended penalties in line with what we more typically see rather than atypically see for Rule 207. I'm certainly open to continuing it to have that discussion. But in lieu of that, if we're talking about a full application or that's kind of where we would need to be providing direction, I'm not sure that that's a pragmatic enough solution for me to ultimately get to what I would hope would be significant and consistent future compliance. I don't think that necessarily accomplishes at least what I would hope that it would accomplish. And I think at that point would probably be inclined to support staff's approach, which I think is a pragmatic approach, to still ultimately get to that significant and consistent future compliance. So that's where I'm at.
Further discussion on the motion? Hearings Manager Thomas, let's take a roll call.
Commissioner Ackerman.
Thanks. Acknowledging all those that have made good choices and worked hard to rectify this since its discovery, respectfully, I'm a no.
Commissioner Cross.
Yes.
Commissioner Messner.
Yes.
Commissioner Oath.
Yes.
Commissioner Robbins.
Yes.
Mr. Chair, the motion passes 4 votes to 1.
Okay. I know, I hope folks understand that we take our job seriously and this is not easy and this is difficult and we're trying to do the best for the state of Colorado. Director Murphy, do you need anything further from us at this point now that we have a motion that's passed that accepts the AOCs?
Thank you for asking, Chair. I don't believe so, but if AEG Boudreau or Jeremy have an issue or a question, please, I'd love to have them raise their hand. But I think I'm good.
I don't have anything else, Mr. Chair.
All right. That matter is concluded and appreciate the various perspectives of commissioners as we debated through that. Next on the agenda is the Health Study Panel Report, and that's going to be from Commissioner Oath. Can I give you 5 minutes, Commissioner Oath, to get ready?
That would be great. Thank you.
Is 5 enough?
Yes.
All right, let's return at 11:11. The Energy and Carbon Management Commission, we're coming back on the record on June 24th. It is 11:11, and we now will take up two matters. Both are kind of reports from various folks to us. The first is a report from Commissioner Oath on the health study panel that she was charged with leading. And then following that, we will have an update on community engagement commitments and use of public comments and decision making from two members of our staff. So these are important topics, and we look forward to hearing from them. And before you get started, Commissioner Oath, let's make sure we got Commissioner Ackerman with us.
Sorry, Mr. Chair, forgot to turn on the camera.
No worries. Oh,
Nope, you got muted, Mr. Chair.
okay. Yeah, you are recognized, Commissioner Oath.
Okay, thank you so much. So good morning. Just again, I guess for the record, my name is Tricia Oath. I am one of the governor-appointed commissioners for the Energy and Carbon Management Commission. I was appointed to fill this seat for a commissioner with expertise in public health. And so on behalf of the commission, I chaired the panel that this commission convened, and it is for that reason that I am presenting today to share an overview of the panel and the process, as well as a summary of the panel's findings and the key takeaways from the studies reviewed. So over the past several years, researchers have published important new studies examining public health and oil and gas development in Colorado. Because these studies generated significant public interest and raised important questions, the Commission wanted to better understand the findings, methodologies, limitations, and implications of the research. Rather than reaching conclusions on our own, we assembled a multidisciplinary panel of experts representing public health, medicine, toxicology, epidemiology, environmental justice, air quality, environmental policy, and energy regulation. The goal was simple: carefully review the science and help the Commission better understand what the studies do and do not tell us. And this effort reflects the Commission's commitment to transparency, scientific understanding, and informed public discussion. While there are additional studies that have been published on this topic that may provide further insights and be of great value, the panel did not conduct a comprehensive literature review, nor select these studies based on a determination that they are the most definitive. Rather, the panel focused its attention on these three studies because they are recent studies. They are focused on Colorado sites. They utilize data collected in Colorado, and also because these three studies were highlighted by ECMC stakeholders and identified by commissioners to be of interest in the convening of the panel. The panel's discussions focused on understanding the studies and the key takeaways for further understanding risks to public health from a community exposure lens. The panel did not focus on potential worker impacts for those in closer proximity at sites. I want to say that the review process was intentionally thorough. The panel met directly with the authors of each study, reviewed the methodologies and findings, discussed limitations, and engaged in thoughtful conversations about remaining research questions. Because these studies address important public health questions, we prioritized a thorough and transparent review process over speed. The Public Health Studies Review Panel consisted of experts representing public health, medicine, toxicology, epidemiology, environmental justice, air quality, environmental policy, energy regulation, and stakeholder engagement. I'd like to express deep gratitude for each of the members of the panel for their participation. Their expertise in understanding the research that exists in this field and ability to understand the complexities involved in this research were invaluable in helping the Commission better understand these studies. I have every confidence that their work is going to lend significant value to the Commission's understanding of the studies. I would also like to thank the authors of each of the studies, and specifically Drs. Collette, Pan, McKenzie, Allshouse, Weisner, and Varner for taking the time to meet with the panel on multiple occasions. At one point in the process, one of the researchers said to me that it is a researcher's dream for policymakers to take a hard look at their work and to consider how to incorporate their findings into policy decisions, and they were very appreciative of the Commission's approach here. I would like to say that from my perspective, it is also a policymaker's dream to have researchers within our state who are doing work to help us better understand the potential health risks associated with oil and gas development, and to have them meet with a panel like this in order to help further inform our discussions. The report from the panel it does a number of things. So it summarizes the studies that we reviewed, and it can help inform policy discussions going forward. It does identify future research opportunities, and it helps educate the Energy and Carbon Management Commission and the public on learnings and limitations from the studies. The report does not change rules. It does not determine permit outcomes, and it does not make policy recommendations. All right, so I'd like to get into some discussion now about the panel's findings with respect to each study, taking one at a time. This first study on cumulative human health risk assessment was led by researchers at the Environmental Defense Fund. This looked at exposures to VOCs and ozone for individuals living in Broomfield. The study results generally found that chronic risks were below health guideline levels. In other words, chronic risks are generally well managed at the sites in the study, which is consistent with previous studies. With respect to acute risks, there are kind of two main key takeaways. First, with respect to acute risks during pre-production activities, previous studies and this study identified acute concerns during pre-production activities, so during well drilling and completions, including hydraulic fracturing, in close proximity to the well pad. So for immunological and developmental endpoints, oil and gas was the primary driver. For the respiratory endpoint, ozone was the primary driver, but the addition of oil and gas exposure pushed the acute level above EPA thresholds. So, in other words, the study demonstrated that when a person is exposed to both VOCs and ozone at the same time, it could contribute to acute exposure risks, which warrants additional study. Secondly, with respect to acute risks, acute levels of VOCs exceeded EPA thresholds for three non-cancer health endpoints: respiratory, immunological, and developmental, during production at one site where the monitor was located in the community, approximately 1,000 feet from the well pad. Separator maintenance was the main cause of high VOC levels at this site. It's important to note that these levels were observed during production only at one site, and that site was 1,000 feet from the pad, which does create some limitations in usefulness for regulatory bodies such as ours making siting decisions at further distances. I'd also note that in this study, which is actually the case across the studies and is common, that the findings reflect operations that were occurring during a period of rapidly improving statewide best management practices. So this can complicate findings in both directions. On one hand, practices occurring today may already result in less exposure than what was occurring at the time of the study. And on the other hand, these are sites where the practices may be more advanced than in other cases and may not be representative of the practices employed statewide by all sizes of operators. So the bottom line here that the operational practices used at these sites are similar to those being required in the DJ Basin in Colorado for sites near communities. Moving on to the second study. This study was led by researchers from Colorado State University and supported by the Health Effects Institute. The panel focused on two parts of this study, the first being measuring and modeling of air pollution, and the second being the development of a tool that can be used by community groups. There was a third part of the study that was related to noise exposures, which this panel did not discuss. So for the first part, researchers measured pollutants at 4 sites in the DJ Basin and compared that with activity logs from operators to understand what activities were occurring when various pollutant levels were observed. The study team compared observed air pollutant concentrations with established health-based guidelines to assess health risk for local populations. They found no exceedances of chronic health guideline values detected at 2,000 feet. The 1-hour benzene concentration occasionally exceeded the acute health guideline value, which is consistent with previous studies. However, those levels were observed at locations near to the well pad and were not observed at the fence line nor at a location in the community. When modeled, the study determined that by the time those plumes reach 2,000 feet from the well pad, they are below all health guideline values. While concentrations of the hazardous air pollutants varied considerably, for the operations at the 4 sites studied, a 2,000-foot distance was found to be protective. This slide includes a graphic to illustrate the concept I just discussed, which is that plumes with high pollutant concentrations may occur in close proximity to the well pad, but concentrations generally decrease the further the plume moves away from its source. In this study, by the time the plumes reached 2,000 feet from the pad, modeled concentrations were below health guideline values. There are some specific activities that were identified to be associated with notable influence on pollutant concentration measurements. First, the largest benzene and total VOC emissions were seen during drilling and during coil tubing and mill-out operations. On the flip side, the study observed a greater than 95% reduction in average VOC and benzene emissions during flowback operations for sites using closed-loop tankless systems versus other green completions. However, even so, large transient emission plumes occurred during the emptying of sand canisters. And the second part of this study that the panel discussed is the tracer tool. So the tracer tool was developed to predict chemical emissions and exposure associated with oil and gas activities at distances of 1,000 to 1,500 feet from the well pad surface and timescales relevant for community exposure assessment. The tool's projections allow different operational scenarios and could be used to evaluate the effectiveness of mitigation strategies during pre-production operations. At this time, the tool is intended for use by community members, and I believe it offers great potential to understand opportunities to reduce exposures in the real world, but it is not intended for use in regulatory settings at this time. Additional data would be needed to evaluate the tool's ability to predict concentrations. Moving now to the third study. This study was led by researchers from the Colorado School of Public Health. It explores whether residential proximity to oil and gas development is associated with an increased risk of acute lymphoblastic leukemia, or ALL, in children. The authors focused on 451 children born in Colorado between 1992 and 2019 who were diagnosed with ALL between the ages of 2 and 9 years old. The panel found that this was a well-designed study. In terms of key takeaways, the studies found an association between oil and gas development and ALL at distances of 3 kilometers, 5 kilometers, and 15 kilometers, and that the density of wells and the phase of development, or in other words, the intensity of the emissions, also contributed to increased risk. However, the panel indicated that caution is warranted in interpreting this study. On one hand, this study represents an advance in considering intensity of exposure to oil and gas activities, not just proximity, and builds on previous studies from the same lead author finding an association between oil and gas development and childhood disease. However, the study design and the results do not support concluding that living near oil and gas causes ALL. While the study observed an association, or in other words, a correlation, it was not designed to assess whether proximity to oil and gas activities or emissions causes ALL. The study did not attempt to estimate exposure to specific chemicals such as benzene. Furthermore, there are large, high-quality community studies that have not found an association between benzene exposure and ALL in children. More research would be needed to draw clear and definitive conclusions and to evaluate exposure levels in communities, either through evaluation of existing exposure data or the collection of additional data if needed. One expert that I talked with shared this analogy with me that I found helpful. These studies of associations are like indicator lights or a check engine light. It tells you that something might be going on, but it doesn't tell you definitively what is causing it or what to do to address it. So For example, in your car, if the indicator light goes on, you might need to bring it to the shop to get more information, but you most likely wouldn't just buy a new car or start replacing your tires without that additional information. Overall, the studies illuminate the importance of cumulative exposure research, that operational practices matter. They highlighted the distinction between acute and chronic risks, that there is a need for continued scientific evaluation, and that determining causation of an endpoint is a complex endeavor. The panel found that the studies provide valuable new information and contribute meaningfully to Colorado's understanding of public health and energy development. At the same time, the panel identified limitations, uncertainties, and opportunities for additional research. Some findings suggest areas that warrant continued attention and scientific evaluation, while other findings indicate the importance of operational practices and exposure reduction measures. The report does not attempt to settle scientific debate. Instead, it provides a balanced summary of what the studies found, what conclusions can reasonably be drawn, and where questions remain. Ultimately, the panel's work, as reflected in the report, is intended to improve understanding, not to declare final answers. I want to pause on this slide for a bit to allow anyone who's listening in to use this QR code. The report from the panel and the supporting materials are available from the ECMC website. You can access it using this QR code. For those looking to access the information without the QR code, the information will be under the navigation for data, maps, and reports, and then a tab for special projects. So I want to be clear that I've been doing my best to provide a summary of the panel's work, reviewing the 3 studies and providing insights regarding the scope of the studies, the methodologies and limitations, the key findings and takeaways, and opportunities for additional research. But I am going to transition now into my own personal reflections and some thoughts that I would like to share with my fellow commissioners on next steps. I've been thinking a lot throughout this process about what the appropriate next steps are based on what we have learned from these studies. And, one thing that my experience in public health has taught me is that the principle of weight of evidence is a broadly relied upon principle in environmental regulation and an important one in this context. So the graphic, this is a busy slide, I apologize, but the graphic on it is one that is borrowed from our sister agency at the Department of Public Health and Environment. And it uses this graphic to illustrate how individual studies contribute to a body of knowledge that then funnels into the establishment of environmental standards. The key point is that relying on a single scientific study to drive public policy or regulatory decisions is inherently risky, as individual papers can be outliers, they can be limited by small sample sizes, or influenced by localized variables. Because a solitary finding often raises more questions than it definitively answers, treating it as an absolute conclusion rather than a prompt for deeper inquiry can result in premature or misdirected regulations. Science progresses through replication and stress testing. A single data point serves best as a directional signal pointing toward where subsequent rigorous research must be focused to confirm a true trend. Ultimately, basing policy on the collective momentum of science rather than an isolated finding ensures that regulations are scientifically resilient, capable of maintaining public trust, and legally defensible. This is my last slide. So my personal takeaway is that I do not see that these studies are a basis to immediately revise our regulations, including the setback distance. However, action is warranted. I would like to invite comments from stakeholders to hear what thoughts people have about next steps that this commission should consider. In that vein, I would like to ask staff to develop a mechanism to collect comments from stakeholders and then come back to us with a summary of the comments that were provided and some options for us to consider. Second, I recommend that we direct staff to consider some specific best management practices and activities that were identified across the studies to see if there are additional opportunities to reduce emissions from certain activities or through the use of certain best management practices. The examples that come to mind to me from my review are closed loop tankless systems, separator maintenance, coil tubing and mill out operations, and the emptying of sand canisters during flowback. Third, I think that we should invite the air quality enterprise to a commission meeting. I would be very interested to have a discussion with them about collaborating together on research to help us all better understand the cumulative impact risks from multiple pollutants and from multiple well pads, and considering density and phase of development. And fourth, our community relations unit has a community informational meeting scheduled for July 21st, and I recommend that at that meeting, we offer to present an overview of the panel's findings. Once each of these elements has taken place, then I would expect that we would have staff come back to us with a summary of the written comments and input received. And informed by that feedback, the discussion with the air quality enterprise and the evaluation of the identified best management practices and activities to provide us some options for us to consider and discuss as additional next steps. In conclusion, I hope this report helps communities, policymakers, researchers, and stakeholders better understand both the findings and limitations of these studies. The Commission convened this panel because we believe emerging science deserves thoughtful review and public discussion. Scientific understanding will continue to evolve. Our responsibility is to understand the best available information, operate within Colorado law, and continue our commitment to protecting public health while ensuring decisions are informed by sound science and transparent processes. Thank you very much.
Thank you very much. An outstanding amount of work is obvious here, given the breadth and depth of your presentation this morning. I applaud that, and I appreciate and am, at least initially, very much in favor of the next steps as you have outlined them on that last slide. That meeting with the community relations group might also be an opportunity to tell everybody about that last slide and the opportunity for additional comment coming in. Commissioners, questions, thoughts for Commissioner Oath? Commissioner Messner?
Commissioner Oath, I want to just express my appreciation for the work that you and the panel did on this. I don't have a science background, and so I depend on you as the commissioner in the health seat and the studies that I read and the information that's provided to me to help make the best decisions in my role as a commissioner and for the state of Colorado. And I know that the evaluation and understanding of these studies is complex and layered, and details matter. And I really appreciate the time that you and the group have taken to really evaluate the different studies, these 3 different studies, and independently make determinations on that in the report. And so I've read the report. I really appreciate the information that's within it. It certainly is going to help me in my decision making. And so fully support your thoughts on next steps. I think those are good, pragmatic next steps for us to look at as we continue to try to ensure that what we are doing here is protective. And so I just wanted to say thank you.
Commissioner Ackerman?
Thanks, and I'll say the same. I again appreciate Commissioner Oath's attention to the issue. Certainly, it's something we're all focused on, and I particularly appreciate Commissioner Oath you coming back with a concise report, but also proposed steps forward. I'm also in support of those steps forward. I do think further action is warranted to continue to examine the issue and how we move understanding forward, and agree with the statement that you made that a single data point certainly shouldn't be pointed to as a conclusion and be a policy driver, but that the collective momentum of science is a very important consideration as we move forward. I did just have one question for you. You mentioned a few times emissions being below health guidelines, and concentrations being below those health guidelines. Would you expand just a little bit on what those health guidelines are, where they came from, and why they were used as standards?
Yeah, thanks, Commissioner Ackerman. It is a great question, and I think I will say thank you for your expressions of appreciation, and I think all credit goes to the panel members. While I do have, background in public health, I'm not a toxicologist or an epidemiologist, and so I have learned a lot throughout this process. And one thing I have learned throughout the process, and that came up in kind of the writing of the report, was around this. And in some cases, we were wanting to refer to kind of standards, risk thresholds established by EPA. So in many cases, the health guideline values that the data was compared with were things that were established by the Federal Environmental Protection Agency. But I also know that it was clear from panel members' review that there were also other standards determined by very credible groups. And all of those go through kind of that sort of filter slide is kind of a demonstration of a process that would be used for the establishment of a health guideline level, right? It would be a lot of individual studies and information gathered together to work towards the establishment of those thresholds.
Thank you. I really appreciate that. Often science works on the best available science, and it sounds like from that filter model that's exactly what those standards are established by, and is exactly how we work as a commission, that we work with regard to the best available science at any point in time. So thank you so much.
Yeah, thanks.
Commissioner Cross?
Thank you, Mr. Chair, and thank you, Commissioner Oath, for all the hard work on this, as well as to the panel. Obviously based off of a lot of the comment we've received, both during our normal hearings, as well as written comments, as well as during the 511 hearings. In particularly, the ALL study has been important, but I also really appreciate the fact that you looked at additional studies as well, and really broadened what we're looking at, and especially because they weren't all focused on the exact same thing. So I do really appreciate the hard work on that, and I just want to also second that I think the next steps that you proposed, I am in favor of, and I will also be interested to hear stakeholder comment once they have had a chance to digest the report as well.
Great. Anything further?
Well, thank you all, and thanks, Mr. Chair. I think maybe I will just say that given that some of the recommendations I was making for next steps involve working with staff, I will I'll be working with Deputy Director Mercer-Gelman and others to carry forward these next steps. Thank you.
That sounds great. Thank you so much. All right, let's just do another quick 5. Let's return at 11:45, and we'll hear our last panel today. Thanks. Okay, welcome back. Energy and Carbon Management Commission, June 24th, the last part of our business agenda. We are going to hear an update on community engagement commitments and use of public comments in decision-making. We've got Lauren Mercer-Gelman, ECMC Deputy Director of Policy, and Stephen Araza, ECMC Environmental Justice Community Liaison from the West Slope. Take it away, you guys.
Thank you, Chair Robbins, and good morning, still barely morning, to the commissioners and the public who are listening in. As Chair Robbins said, I'm Deputy Director Lauren Mercer-Gelman, and I'm joined by Stephen Arauza, our West Slope Environmental Justice Community Liaison. So just to set the stage, at the Commission's hearing 2 weeks ago, Chair Robbins shared that ECMC received a letter from a coalition of community-based organizations requesting the development of guidance on how the Commission exercises its discretion. And as referenced in this letter, that request has sort of grown out of conversations between those community groups and members of ECMC staff. So Chair Robbins asked us to come before you today to give some context about those discussions. So that's why we're here. Next slide, please. Um, and my colleague Stephen Arauza has been leading a series of thoughtful discussions with these community groups since they sent a letter to ECMC about a year ago requesting that ECMC implement a number of new practices to improve community engagement and transparency. Stephen has led those conversations. I've been a part of some of them, as has Trisha Oath and some other members of the Community Relations Unit. Today, Stephen is going to tell you about the requests, progress toward them, and where they currently stand, specifically including the request for this discretionary guidance. Then he's going to bring me back to the mic to tell you about a new resource that we've published yesterday related to public comment that is related to this conversation. Stephen, take it away.
Thank you, Lauren. Good morning, commissioners. I had to check the clock to make sure I can still say that. I appreciate this opportunity to address the commission regarding some of the community engagement work that the Community Relations Unit, which we refer to as the CREW, has been working on over the past year. I also want to thank you, Chair Robbins, for extending this invitation to the CREW and for formally acknowledging the receipt of the letter from the community-based organizations regarding the discretionary guidance that was dated June 4th, 2026. Having spoken with a few of the letter's signatories over the past 2 weeks, I'm happy to report that Chair Robbins' acknowledgement of the letter during the June 10th hearing was received with optimism. This first slide provides an abbreviated overall timeline of this work. It begins with the advocacy work of Citizens for a Healthy Community during the mission change rulemaking in 2020. And as described in the letter, this work has been joined by other community-based organizations, which we refer to as CBOs, in subsequent rulemakings since then. This includes the 2024 Cumulative Impacts and Enhanced Systems and Practices rulemaking that also included defining my role as an environmental justice community liaison. In March of 2025, it's the second section here from the left, the Community Relations Unit hiring was complete. Technically, I was the last one in the door, but that's because I still had a number of Form 27s to wrap up as an EPS before making the transition. As soon as the Community Relations Unit was assembled, we set out to build the Energy and Carbon Management Commission's Community Engagement Plan. In May of 2025, the CREW hosted a series of open house events to present our work and to solicit input on the Community Engagement Plan. Chair Robbins participated in our Denver open house, and thank you again for your support of our work. Since the May 2025 meeting had asked for input on the plan, community-based organizations provided their feedback in the form of a letter to the CREW and the commissioners dated July 7th, 2025. This letter provides feedback on the Community Engagement Plan, general support of the CREW's work, and a list of 7 specific requests that I'll describe over the next 2 slides. There was some internal discussion in response to that letter, expressing concerns over whether or not the requests would require additional rulemaking. So we set up a meeting to discuss the letter with the people that signed it. This meeting took place on August 26th, of 2025, and included both the community liaisons, our CREW manager, and our intrepid support staff, along with Deputy Director Mercer-Gelman and Commissioner Oath, to discuss the feedback and requests described in the letter with the people and organizations who provided them. The meeting was friendly and productive. It was a highlight of our work at the CREW to have had the support of leadership in this space, and Commissioner Oath described the meeting positively when she reported it to the Commission at the hearing on September 3rd, 2025. During this meeting, the ECMC and CBO representatives arrived at 8 commitments that have been a portion of the CREW's work ever since. From the August meeting until now, the CREW continues to work to implement these community engagement commitments in addition to executing the ECMC's larger community engagement plan and, of course, prioritizing our regulatory work. This is a general timeline and context that has led to the June 24th, 2026 letter and to today's presentation. With the next slides, I'll discuss some more of the specifics. The July 7th, 2025 letter included a list of requests that I'll cover in the next 2 slides. The enumerated quotes on these slides are pulled directly from the letter, while the icons on the right are intended to indicate the status of each request. These requests do not completely overlap with what we've described as the ECMC commitments. Those came after our August 26th meeting. So starting at the top, the letter signatories asked for community impact tours with ECMC commissioners. I'm happy to report that my colleague Jessica Chavez has been working with internal subject matter experts to plan these tours, and the first one will occur in the West Slope in August. Next, the community asked for community training sessions and regular meetings with communities. These asks were intended to provide parity for the community with time and training that is allotted to LGDs and operators respectively. So these are points 2 and 3. I grouped those together because the crew has managed to facilitate both of these requests with our informational community meetings, which I'll describe in more detail in a later slide. The final request on this slide is related to the tone of the June 4th letter that we've received this month. And you'll notice throughout this presentation in the timeline that there has been an evolution of these requests. Last July, the request was for development of eligibility criteria to essentially redline areas that are off limits to production. The icon for this request indicates that it has not been delivered by the crew or the agency. This has to do with the complicated and site-specific nature of the permitting process, in which local governments, tribal governments, and other land use authorities share jurisdiction over making those determinations. Request number 5 also persists into the June 4th letter, as it is the request for development of denial guidance. The next request was for a list of operators with repeated compliance issues. This request was determined to not be feasible based on the dynamic nature of regulatory compliance, although the community-based organizations were directed to where they would be able to find the NOAVs, which are all publicly available on our website. And the final request in that letter was for the ECMC to develop a website that focuses on the data and navigation needs of our community. The letter signatories acknowledged that our website refresh was a step in the right direction, but this is a request above and beyond our initial update. We've identified this request as a work in progress, since the new website has been designed to solicit feedback from users. I also want to give a shout out to our colleague John Brown, our Public Information Officer, for his attention to community needs regarding our website and for his innovative ideas that overlap well with this request. So in response to that July 7th letter, the crew and others at ECMC met with the letter signatories to discuss their requests in details and assess their feasibility. The next 2 slides describe the commitments that came out of that meeting. And I want to reiterate that it was a very collaborative conversation and that allowing the signatories time to describe their requests really put the agency rulemaking concerns at ease. So again, from the top, the signatories' requests were grouped into topics, which are represented on the left side of these slides, with specific commitments described on the right. Regarding commissioner engagement, we discussed community-led impact tours, the first of which is scheduled for August of this year. Additionally, on the next step, Commissioner Oath committed to providing her update to the commissioners regarding that meeting, and her comments were provided again in the September 3rd, 2025 hearing. Under the topic of education and training, we discussed hosting regular community education meetings, which we've delivered on in the form of our informational community meeting series. Also under education and training, the signatories asked for the agency to provide opt-in notification options, with the goal of mirroring LGD notifications for community members who request them. Our commitment from this meeting was to explore the concept. Under transparency and guidance, the crew manager committed to assessing the public availability of datasets used in the OGDP review process. We also committed to the development of a community newsletter to proactively provide data to the public. This has become our carbon copy newsletter. Under decision-making and denial guidance, crew and Deputy Director Mercer Gelman committed to continuing the conversation, which has become the topic of the June 4th letter. And finally, the crew committed to creating plain language information sheets specific to several ECMC forms. So I'd like to take a moment to describe our informational community meetings in detail because they really exemplify the level of commitment of the entire agency to these community engagement goals. The informational community meetings, or ICMs, represent a significant commitment of ECMC leadership, our director, management, and supervisors to support a space for the public to learn about our work. I've been proud to work on these meetings alongside John Brown, our Public Information Officer, and none of this would have been possible without Kristen Kemp, our previous crew manager and John's PIO predecessor. The ask for a community meeting was a simple ask for parity with our monthly 1-hour operator meetings. But with the support of leadership, the agency has been able to over-deliver in this regard. To date, each monthly ICM has been the result of about 30 hours of dedicated time from our subject matter experts, another 30 hours, or 40, from myself and our PIO, and on average about 40 hours of contractor time to handle logistics, interpretation, and PDF accessibility. When compared to the roughly 10 hours of prep time that is estimated for each operator meeting, the level of commitment is made clear. Of course, the goal of the crew is to streamline this process to mitigate the significant asks of staff time. And I want to thank leadership for allowing us the resources to develop and refine this meeting series, as well as Director Murphy, the LAS team, the compliance unit, and our cumulative impacts team for delivering excellent information in our first few meetings. In keeping with environmental justice best practices, these meetings are held in the evening on every third Tuesday of the month. So I especially appreciate my colleagues for committing their time after hours to show up for the public. One of the most important elements of these community meetings is that they are actively building a 101 level public archive of ECMC operations. ICMs are posted to a specific playlist on the ECMC YouTube page because not everyone can attend the meeting live. As of this morning, the 4 ICMs on our YouTube channel have received about 200 views, with 30 of those being specific to our Spanish language content. As an EJ community liaison who comes from DI communities, I'm especially proud of our agency's commitment to language access in this space. These next 2 slides represent the status of the ECMC commitments that were made during the August 2025 meeting with letter signatories. And we'll start with the highlights. So from left to right, the ECMC form summaries are posted on the Community Resources page of the ECMC website under the button marked Understanding ECMC's Forms. Currently, summaries can be found for our Form 2A, Oil and Gas Location Assessment, and Forms 18 and 18A, the complaint forms. Public education is underway in the form of our informational community meetings. I think I've said enough about those, but please be sure to check out our meeting archives on YouTube and tell your friends to tune in every third Tuesday on Zoom. More information can be found on the Community Resources page under upcoming community events and meetings for these and other public meetings. Regarding commissioner engagement, our PAC tour is scheduled to take place in August. My colleague Jessica has been working to deliver a meaningful experience for this group of commissioners as well as stakeholder participants. And on the transparency and guidance front, ECMC's Carbon Copy newsletter has been going strong for some time now. John Brown and others work diligently to deliver informative content to subscribers each month. And currently there are over 3,600 subscribers on the Carbon Copy distribution list. I've grouped the more challenging commitments on this slide. From left to right, crew explored the possibility of opt-in notification requests. It was determined that build-out of a public-facing infrastructure that mirrors our LGD notifications is not feasible at this time, as our agency's IT resources are committed to the COGIS modernization effort. The assessment of the public availability of datasets relevant to the LAS process has yielded limited results. This is primarily due to the fact that draft applications are the primary subject of review, and these drafts are not made publicly available because they're works in progress. The LAS team delivers on transparency, however, by providing a detailed spreadsheet that documents the process of their work, from the moment a draft is received until it is determined to be complete. It is at the completeness stage that the draft becomes publicly available, at which point it can be reviewed by the public alongside our ECMC map viewer and COGIS database, which are the primary tools used by the LAS team. This leaves the commitment to continue the conversation regarding the recommendation for denial guidance. During our initial conversation with this group, we conveyed that denial criteria is not something that could be developed outside of a rulemaking. So we continue to refine the conversation to arrive at this point. Even as refined, the topic is above staff's authority, and we appreciate the commission, or that the commission is engaging in this discussion. We believe that strong collaborations on both sides of the conversation have resulted in the evolution of this request from denial guidance to discretionary guidance, as described in the June 4th letter, which I'll describe in the next 2 slides. So these slides are meant to provide a few highlights from the June 4th, 2026 letter, which was acknowledged by Chair Robbins in the June 10th commission hearing. The letter indicates that Citizens for a Healthy Community started advocating for denial criteria during the mission change rulemaking in 2020. It also states that several groups have joined this effort since then, including presumably the letter signatories who have been working with CREW over the past year. The letter identifies the Commission's willingness to commit to exploring development of a denial guidance. This is in reference to the ECMC commitments that I've described from the August 2025 meeting. Let's see, but to be clear, the commitments were made by representatives of the agency and the CREW, and they were not made on behalf of this Board of Commissioners. In a subsequent conversation with the letter signatories, it was confirmed that their letter was not intended to imply that our commissioners had made that commitment. I just want to clear the air because the verbiage there is a little clunky when I try to make the distinction. Let's see. So this letter is also specific to Rule 307B2 and the topic of commissioner's discretion. The specificity of the letter is reflective of the ongoing conversations on this topic between the CREW and letter signatories. The refinement of the ask from 2020 to 2025 to now represents the collaborative nature of a working relationship between the letter signatories and CREW. The letter also cites the external-facing nature of ECMC's guidance documents and policies, while pointing to a lack of similar guidance specifically for our commissioners. And finally, the letter includes a specific ask that the ECMC Director and Deputy Director of Policy work with the group of community-based organizations to develop discretionary guidance by August 30th of 2026. And let's see. So, thanks to the specificity of the ask, I thought it would be prudent to provide the language of the specific rule in question, which is Rule 307B2. I'll pause here for folks to read through this rule and hand the slides over to Deputy Director Mercer-Gelman at this point. So, Lauren, whenever you're ready.
Thank you, Stephen. I'll give just another moment to read the slide. All right, let's move to the next slide. So as I sort of previewed at the beginning of our presentation, I'm here to tell you about a new resource that we've developed, which is a document explaining how ECMC uses public comments and permitting and tips to the public for how to make effective public comments. Now, this is not directly responsive to the requests from the community groups that Stephen just discussed, but was actually the brainchild of our former communication, our community relations manager, Kristen Kemp, and is something that we've been working on for quite some time. But it is quite related to the content of the letter, so we thought it would be important to talk about here today. In particular, the June 4th letter referenced a recent commission decision that was the subject to a lot of public comments, and so that makes it directly relevant now. And so we created this because public comment is a really important part of our processes here at ECMC. But we frequently hear questions about how public comments are used, and frankly, whether we're really listening. This is our attempt to provide some answers to those questions. The document focuses on public comment in the permitting context, though of course the Commission receives public comment on all matters within its jurisdiction, and I think the principles of this document can apply more broadly. As I mentioned, we've been working on this for quite a while. To prepare the document that we published yesterday, I had one-on-one conversations with each commissioner that identified a lot of common themes in how the individual commissioners use public comments in their decision making. I also had discussions with our permitting staff and our AAGs. And so because we describe in this document how the commission uses public comments, following our presentation, I would ask the commissioners to let us know whether staff got it right. Next slide. So this document is available on the public comment webpage, where the public goes to sign up for public comment. The easiest way to get there is to use the search function on ECMC's website and just type in public comment. It'll take you straight there, and this document is linked on that page. In the document, we cover the following topics. First is how ECMC staff, distinct from the Commission, uses public comments in its permit application review. As the permitting staff has shared in a previous presentation to both the Commission and at an ICM, staff's permit review is strictly rule-based. So the comments that are most likely to influence staff's recommendations for approval or denial are those that are tied to whether a permit application complies with specific rules. We then talk about how public comments influence commission decision-making. And include real-world examples of how this has played out in past commission decisions. As we've discussed, the commission's review of an application entails a level of discretion, right? So the commission has, along with that, a broader use for public comments. And in my next slide, I'll go through all of the different ways that were identified that public comments play into the commission decision-making process. I particularly hope that folks will find the examples of how this has played out in practice helpful. The next section of the document is public comment myth versus reality, in which we attempt to address some common misconceptions that we've heard from folks about public comment. Then we go over the different opportunities for folks to make public comments. As the Commission is aware, we have both general public comment and OGDP specific comment. We also accept both written and oral public comments. And finally, the document concludes with some tips for how to make your public comment as effective as possible. Steve, next slide, please. Thank you. So this is a brief summary of how public comments inform commission decisions, which again is a very holistic review of an application. So these were some of the themes that emerged in my individual comments with the commissioners. The first is that public comments can provide insight on whether an application complies with the rules. Several commissioners referenced this as being the most important function of public comment, and sort of the types of public comments that are most likely to weigh into their decision making. Another use of public comments is to allow the public to highlight new information and resources that the commissioners might not be aware of. An excellent example of this would be the public health studies that Commissioner Oath just described. As I believe Commissioner Cross referenced in his comments, we received a lot of public comments about these studies. That really elevated them to the Commission, showed us the importance to folks of these studies, and helped lead to the creation of the panel that Commissioner Oath just discussed. Another important function of public comments is that they're a place for the public to point out to the commissioners where there might need to be additional scrutiny of an application. So either they see shortcomings in an application or particular risks or impacts that commissioners should take a better look at. And while this document focuses on the permitting context, I think we actually also saw this play out this morning in the discussion of the enforcement AOCs. Public commenters commented on the appropriateness of some of the actions taken by staff in coming to those AOCs, which allowed the commissioners to really drill down and ask questions of staff to obtain the rationale and question the justification behind those decisions. Another important function of public comments is to amplify community concerns and lived experiences. We are very cognizant of the fact that the commissioners are just five individuals with different expertise. They do live in different areas of the state, but not in every community where a oil and gas location might be proposed. So it is really important to hear the lived experiences of folks that wouldn't otherwise come to the forefront. Related to that is it's an opportunity to learn the perspectives of those most directly affected by an application, like the landowner, mineral owners, and nearby residents. Commissioners also highlighted that those perspectives are particularly instructive to them. Next slide, please. And so this is just a screenshot of one of the myth versus reality points that we took on in the document. And I chose to highlight it because it echoes a point made in the June 4th letter about the fact that the commission approved an OGDP despite significant public opposition in the form of public comments. So the myth, as I framed it, is I commented in opposition to an application and ECMC approved it anyway. They must have just ignored my comment. And we wanted to address what I think are a few important points around this. First is that staff and the commission are required to consider all substantive public comments by our rules. And I think we do. If you listen to the commission deliberations on OGDPs that receive public comments, you'll find that the commissioners consistently do discuss those public comments in the context of their decision making. So they are absolutely considered. However, at the end of the day, the commission is also a state agency that's bound to operate within its statute and regulations. So all decisions must be made based on whether an application complies with those legal standards. And sometimes every legal standard can be satisfied even when there's public opposition to a project. And the final point, I think, is a particularly salient one, which is that influencing an application can be more nuanced than just approval or denial. We've seen many instances, and several of them are noted in the real world examples in the document, where a public commenter raises a concern and the commission either requires the operator to go back and revise their OGDP, or the commission adds a condition of approval directly intended to address that concern. So while it might not be the black and white deny outcome that folks might be looking for, often public comments lead to a more protective approved application. So I hope folks will take a look at this document. We really hope it'll be a valuable resource. And I look forward to feedback from the community members and the commissioners about whether it is. And if so, if there are ways that we can improve, I would love to hear that too. And with that, I will hand it back to Stephen to wrap us up.
Excellent. Thank you, Deputy Director Mercer-Gelman, for that excellent description and for the significant amount of work that you personally and the rest of the crew had undertaken to put that document together. I've been excited about the publication of this resource for some time now, and I'm glad that we've introduced it to the public and the folks who signed the letter in this meeting. I want to wrap things up with some words from the July 7th, 2025 letter that represent the nature of our collaboration well. In it, the letter signatories indicate that, again, they appreciate the initial first steps to building out a valuable environmental justice community liaison program, and that they look forward to working with our agency toward realizing the full success of this critical component of protecting public health, safety, welfare, the environment, and wildlife resources. So on behalf of the Community Relations Unit, I want to thank this group because we value their continued feedback and collaborative spirit, as we do for stakeholders across the state. I also think it's important to recognize these organizations that signed the letter by name. So this includes Western Colorado Alliance, the Greenhouse Connection Center, Sierra Club, Save the Aurora Reservoir, Physicians for Social Responsibility Colorado, Larimer Alliance, Grand Valley Citizens Alliance, Erie Protectors, Colorado Coalition for a Livable Climate, Citizens for a Healthy Community, Broomfield Health and Safety First, the Black Parents United Foundation, and 350 Colorado, as well as the 8 individual impacted citizens who signed these letters. So this final slide represents the evolution of the ask that is before the commissioners today. As they mentioned in the June 4th letter, the community-based organizations ask for denial criteria predates the Energy and Carbon Management Commission's Community Relations Unit. In the July 2025 letter, the CBOs asked for eligibility criteria in addition to denial guidance. And the continued conversations from the August 26, 2025 meeting have led to a refinement of this ask from explicit denial criteria to denial guidance to discretionary guidance. This represents a collaborative relationship and spirit that has been developed between the crew and public stakeholders. As a representative of the Community Relations Unit, our ask to the Commission is to provide direction to staff regarding what, if any, actions staff should take in response to the June 4th letter. And of course, that is for a future hearing. So with that, I'd like to thank you for your time, and I'm happy to stick around for questions.
Thank you both for the presentation and for the development of not only the public comment guidance document, but also the work that you're doing with the communities that desire to engage further with ECMC. I think we are likely to be one of the more transparent, communicative energy agencies within the United States in terms of the efforts that we do, in terms of the direction we've received from the legislature on DI communities, on comprehensive planning, on cumulative impacts, on 181, you just name it. So I think this is a great evolutionary piece, and I'll look forward to reading through it and at a future date coming back and thinking about next steps, just as you indicated there. So I don't have comments today other than great work, and I encourage everybody to go read it. Others with comments? Commissioner Cross?
Thank you, Chair, and thank you for the presentation. I also just want to say thank you for the hard work. I've listened to those informational community meetings. I think they're very helpful. I encourage stakeholders listening in to do the same. I think it's helpful to provide an overview of what we're really doing at the commission, especially from a staff perspective. And so I appreciate that. I also appreciate all the work the crew has done, not only for our upcoming community impact tour, but also just the different events that you guys attend. I've been lucky enough to attend some of those events as well, and I appreciate it. I think for the stakeholders listening in, I just want to also say, we are listening. I know it's something that we've said at prior hearings, and I know Deputy Director Mercer-Gelman covered it as well. We are listening. Your public comments do form a big part of what I look at as a commissioner, especially in terms of guiding things that I then look for from the operators in the hearings themselves as well. But as I've said at other hearings as well, I'm also open to talking to anyone and everyone. So if you do have discussions that you'd like to have, questions you'd like to raise on not pending applications, but questions on prior decisions or anything else, I'm happy to discuss those with those groups. And I think many of those signatories would also recognize that I have spoken with them, and I'd be happy to do the same with other groups as well.
Commissioner Messner?
Thanks. What are the next steps here? I guess I'm a little gray as to what the next steps are. I know that we're having a meeting about the letter that we received regarding the denial criteria at some point in the future, and looking forward to that. I have a lot of thoughts on that. But as far as the public comment guidance, or perhaps a discussion on how to better structure like hearing presentations and incorporating public comment, are we having another discussion at some point, or I'm a little confused?
I can take a first crack at that. So I guess on the public comment document in particular, we were hoping to basically hear from the commission whether or not we got it right, since I am trying to represent how the commission's process works. So I would defer to you and the chair and others with how you would like to give that direction. I know the only other next step I'm aware of at this time is July 8th, the commission discussion about the discretionary guidance letter.
And is that just at an upcoming hearing at some point, or are we emailing you, or how does that, how are we providing you thoughts on that?
I would say you tell me.
Yeah, I think let's give it a couple of weeks to digest the public comment. Make sure that commissioners feel comfortable that you landed that document in the right space. And then as we do that, I think that helps inform commissioners to come back to you and inform you about this quote denial criteria, the denial guidance, or do we have enough in our current rules? If you don't meet our 164 rules, any one of those can be a denial criteria. So I think all that needs to be next steps for commissioners over the course of the next couple of weeks. And Lauren and Stephen, if you want to work with Elias and find a hearing to sort of calendar this so that we all know we're coming into that to have that discussion, I think that would be great. Stephen?
Thank you, Mr. Chair. I just wanted to just make a quick point of clarification. I've been obsessing over this stuff for about a year now, but others don't have the benefit of my sort of overthinking. Just to be clear, the ask is not for any sort of denial criteria or guidance. It's specific to discretion. I think that the community-based organizations, are very mindful in the specificity of their ask, and I probably didn't make it as clear in the presentation as I should have, but I would consider the denial conversations to have wrapped up and this to proceed as a discretionary conversation.
Well, and I mean, not to speak to that just now because I want to think about it, but I think your public comment document actually does a pretty good job of explaining within it how application of rules or attempted application at rules which don't really work end up as being guidance on whether something's going to get approved or not. But we can have that further discussion down the road, but I appreciate that point. Further comments or thoughts before we close it out for the day? All right. Well, I just, in closing, I want to say this has been, except for the AOC piece, these other informative pieces have been really fun. And I think they do a really good job of showing the depth and breadth of commissioners and our staff and our CRU team to try to be responsive to issues that are raised before us as we try to continue being one of the most transparent energy agencies within the country. So thanks to everyone. Really appreciate it. We've concluded our business. If there's no further comments, I would move to adjourn.
Second.
All those in favor signify by saying aye.
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 That motion passes. Thanks, guys.